You're watching the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. Joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to check out his daily bankruptcy column available on BloombergLaw.com and also on the Bloomberg Terminal. Bill, something really interesting today. I want to pick up on a story that appeared in your column, I believe, yesterday. Homeowners win punitive damage award over Wells Fargo overcharges. This is one whammy of a punitive damages award, $3.2 million relating to one single mortgage and malfeasance. Take it away. What do we have here?
Well, what do we have? We have one very angry bankruptcy judge, the chief bankruptcy judge in New Orleans by the name of Elizabeth Magner. Here's the situation. There was a homeowner who, after years of litigating in the bankruptcy court, was finally able to establish that they had been overcharged by the bank $24,000 on their home mortgage. And they contended that this was a violation of their bankruptcy plan and a lot of other stuff.
So we're talking ultimately about $24,000 in overcharges that ended up in a punitive damages award of $3.2 million.
Exactly right.
That is a very angry bankruptcy judge.
Exactly
Why
right.
is she so angry?
Well, now here's the story. The judge said in her opinion that the mortgage provided that first payments would be applied to interest, then to principal, and last to any other charges that the bank might be claiming. The judge learned, only after some years of litigation, that in fact the bank had a proprietary software system that applied payments not that way, but rather first to fees they were claiming, then to principal and interest. And the result of that would be there would be unpaid principal and interest, and therefore the amount of the loan would get larger than otherwise it should have been. Further, the judge seemed to have been annoyed because they had great difficulty in extracting this information from the bank. So at the end of the day, the judge saw that she was in a, shall we say, a limited position because the circuit court had told her already that she couldn't remedy this situation by telling the bank to clean up its act with respect to other borrowers. That was simply beyond her power to act in one particular case. The door was left open, however, to impose sanctions. This case really demonstrates how persistent an individual has to be able to get things right with a lender.
Bill, didn't the attorneys for the homeowner in this case do this pro bono?
Well, essentially they did, and this is what's really quite remarkable about it. Based upon what the judge said in her opinion, the lawyers for this homeowner must have spent more than $300,000 in time charges, I presume without being paid. It means, in essence, that these lawyers had to work for free for maybe 5 years or so to establish that the bank was not following procedures correctly. And that's what set the bankruptcy judge off. What she did at the end of the day was to say that given, let's call it $310,000 in attorney's fees it took to prove the homeowner was overcharged, she assessed punitive damages 10 times that amount, or in other words, the approximately $3.1 or $3.2 million. The bank, of course, has told me that they have long since remedied whatever problems there were in their servicing system, and they also believe that the bankruptcy judge made some mistakes in fact as well as in law. So I rather suspect that we're going to see an appeal here, and if we do, we can report later on what the appellate courts do with it. But, you know, for me, Lee, what this tells us is that we had a serious endemic problem going to the core of the home ownership, home loan business going back many years. And sadly, now that, the explosion is years over, we're only now beginning to see how truly severe and thoroughgoing this problem was. And I'm not pointing simply a finger at this one bank because we've by now heard enough stories about robo-signing and all sorts of other activities where lenders are either completely overwhelmed by the paperwork or they simply just say, damn the torpedoes, full speed ahead. we'll say or do whatever we have to get the properties back. In any event, Lee, it strikes me that this is an area that needs more rather than less regulatory supervision if we're to avoid a recapitulation of these problems from 2006, 2007.
Yeah, this certainly bears watching. That is an awfully big award. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases or issues we just discussed, be sure to check out Bill's column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacchia. Thanks for watching.